talk to you about how to sell the property of a deceased owner when there is a pending foreclosure. You know, a lot of times when a person passes away, nobody pays that person's mortgage and the property ends up in foreclosure. This is attorney Vernita Williams. I want to share with you some things that I see often here in South Florida and give you some tips about what you can do if you are a beneficiary and you are entitled to a part of the proceeds from this property of this deceased owner. First, before I tell you some things that you can do, I want to deal with two very common misconceptions. Well, a lot of times people think that if a property is in foreclosure, that the foreclosure stops because of the death of the owner or because somebody started probate on the deceased owner's estate. That is not true. Foreclosure will continue, and if you don't do anything to slow it down or stop it, that foreclosure attorney will steamroll right over you and do the next thing. The second misconception I want to deal with is the notion that a beneficiary of a deceased owner can just write the court a letter and say, hey, the owner has died, I need you to give me some more time to get a payment plan or whatever. Well, that doesn't exactly work. The foreclosure attorney here again will just do the next thing towards being able to sell that property in foreclosure. So let me share with you two things that you can do to slow down that foreclosure process and give you time to get a good buyer to sell, or give you time to do whatever it is that you're interested in doing with that property. One of the things I advise people to do always is you need to hire an attorney to do probate for the deceased owner, and you need to make a demand in the foreclosure case itself that they have to have an authorized representative for that deceased owner. And here's why. A lot of times if the owner has died, what the foreclosure attorney does is just serve paperwork on the people who are in the deceased owner's house, or sometimes they will even find the next of kin of the deceased owner and serve them. And once they serve that person, then they'll just steamroll right over you, get a motion for summary judgment filed, get an order of summary judgment, and sell the property. Well, that shouldn't happen that way. When a deceased owner has died and that deceased owner is the person who took out the mortgage, what they're really supposed to do is that foreclosure attorney should be required and is legally required to make sure they either serve a personal representative of the estate, that personal representative being the representative of the deceased person, and if there is no personal representative, they're supposed to have to get an attorney ad litem to speak for the beneficiaries who may have an interest in that property. A lot of times they just skip that step. So if you don't understand that they should be required to do that, and if you don't know what to say in the foreclosure case, they don't do it, and they can just speed forward and get a order of summary judgment to sell the property. So if you demand that they have that authorized representative, that will usually bog them down 2 or 3 or 4 months and give you some time to have a good realtor and get you a good prospective buyer. The next thing you need to do if that property is in foreclosure is you got to show good faith that you're really trying to do something to make some probable or possible disposition of the property. You can't just say the deceased owner is dead and we are thinking about doing probate. When you open probate because the deceased owner is dead and you get a personal representative appointed and you put the property on the market and you have a potential buyer, if the foreclosure attorney sets a hearing saying, hey, nobody paid, I want an order to sell the property, guess what? It's highly unlikely that they can get that order to sell it out from under you if you show the court, we've opened probate, we have a personal representative, we have a potential buyer, we are moving forward. The bank just wants to know that you are doing something to sell this property and get them their money. So, two things. If there's a foreclosure, number one, you need to demand that there's an authorized representative that will speak and act on behalf of the deceased owner who took out the mortgage. Number two, you need to show good faith by going ahead, opening probate, get a personal representative, get a potential buyer, or make a reasonable plan to keep the property if that's what you want to do. But those two steps are necessary, and they can help you greatly when it comes to a foreclosure situation. You don't always have to sell the property for pennies on the dollar and just be under pressure to the point that the realtor doesn't have time to get you a good deal. So if you do these two things that I recommend, you will have a whole lot more time. And there are some other challenges also that can slow down the foreclosure process and give you more time to figure out if you want to sell or what you want to do with the property. I'm attorney Vernita Williams. I've just been giving some tips on what you can do if you are the beneficiary of an estate and there's a property that's in foreclosure, and you want to make sure you don't sell the property for pennies on the dollar, like $30,000 when the property is worth $200,000. So give me a call if you have this type of situation going on. Perhaps there are some things I could do to assist you. My telephone number is 786-831-9483. That is 786-831-9483. Also, if you would like to visit my website, please visit vcwlaw.com. That is vcwlaw.com for more information. Thank you so much for listening.